Hey everyone, it's Rob Ryder. Monday, March 10th, 2014. It appears that it's all about elections, electors and candidates, and it affects your one man, one vote, domicile, your proof of status, where the court of proof is, your right to bear arms, and certificates and declarations. Just to name a few points. This is one of those videos that goes all over the place. Within the offices, the different branches of government, and then how the elections affect them and how they end up affecting you. It's going to be kind of long, and I'll try to make it as interesting as possible, but it's, looking at a lot of documents and then reading what it says is supposed to happen. Right? If A, then B. Right? If A and B, then C. So forth and so on. And if, we just make sure that they're following the law. And if not, well, then the office is vacated and we'll do something about it. Try to. And as usual, I am Rob Ryder, quarterrecord.aol.com. And if you can, donate. It's Ashley Rytlewski at gmail.com is the PayPal account name. Or snail mail to myself, Robert Rytlewski, 10955 14 Mile Road, Rockford, Michigan, 49341. Now, some things that are of interest that we'll be covering are things like declaration of vacancy, among other things. So, just real short here. The members of the Board of State Canvassers shall determine which persons have been duly elected to each office. Makes sense, right? That's on the state level. The board shall certify the determination and deliver the statements and certificate of determination. So there is a certificate of determination that's made to the Secretary of State. The Secretary of State shall immediately execute and deliver a certificate of election to each person elected. If, and that's the big word, if the Secretary of State receives notice before the certificate of determination is issued that the person to whom the certificate of election is to be issued died, withdrew from the district, was declared legally incapacitated by court having jurisdiction, or submitted to the Secretary of State an affidavit declaring the person's intention to refuse the certificate of election, then the Secretary of State shall not issue a certificate of election, and the office shall be declared vacant as of the commencement of the term of office to which that person should otherwise have been elected. Okay, so even though somebody is elected on paper, it doesn't mean that they're elected in real. There's a thing that has to be a certificate of election they have to get. But the big thing is, they could still get the certificate of election if the notice isn't received by the Secretary of State before the certificate of determination is issued. And who issues the certificate of determination? The Board of Canvassers. That's what this is about. Members of the State Board of Canvassers. Okay, so they're going to issue the certificate of determination. And the Secretary of State gets any of these other things noticed prior to that happening, and then he or she won't issue the certificate of election. But if she doesn't, even though she's got the notice now, the certificate of election has already gone out. It doesn't say that they're going to stop it from going out. My point is, does the Secretary of State have on file anything that would say that that person isn't in the office? Whoever that person is, judge, senator, governor, lieutenant governor, attorney general, yada yada yada, because those, they're state offices. County's a little bit different, but not that much. It's just, it's at the county level instead of the state level. County offices, vacancies. If the vacancy in the office of county clerk or prosecuting attorney, it shall be filled by appointment by the judge or judges of that judicial circuit. Now, is that saying that the judge is going to fill the position, or that the judge is going to pick somebody to fill the position? I don't know. Just interesting what it says, right? That county clerk and the prosecutor and attorney, because I don't believe that the person we think is the county clerk is the county clerk. They have some kind of a legal disability, and that's probably the one that most people will have, and that we have, is we are not registered qualified electors within our municipality, within our precinct, within our ward republic. So that's one of the criteria we're going to see for all these offices. You have to be a qualified registered elector. Well, if they are, then that's easy enough to check. You would go check whatever book it's in to see that they are. And number two, if it says they are and they've done it right, that's how you want to do it in your precinct. And that'll take you out of it will then make you a citizen of the state. I'll be a Michigander, right? I'll be a citizen of the state, not a citizen of the several states. A citizen of the state, and by extension then, a citizen of the United States, the U.S. United States. But I won't be a 14th Amendment corporate citizen of the several states. It'll be just one particular state, state of Michigan. That'll be where my citizenship is. And another reason this is important is Local Government and School District Physical Accountability Act. If in the judgment of the emergency manager, no reasonable alternative to rectifying a financial emergency of the local government, which is in receivership, blah, 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 authorize the local government to be authorized to proceed under Title 11 of the U.S. Code. Going to put you in bankruptcy. If the governor approves the recommendation, and the governor shall inform the state treasurer and the emergency manager in writing of a decision with a copy of the superintendent of public instructions if the local government is a school district. This is the crazy thing. Your local government could be a school district. Now, it isn't necessarily the school district that you see when you were driving down the road. Oh, there's a school district. No, because when you think about this, if you go back and look at an old township map, you'll see that there's district schools within the township. Now, a township is only 6 miles by 6 miles, and there's a number of district schools in there. Well, each of those schools has a district. It has a defined territory around it that it would draw the kids from. That's a school district. A one-school district. Which isn't that much different than what a election precinct is. As Bobby in Arizona found out, in Maricopa County alone, in one county in Arizona, there's 740 precincts. 740 precincts in one county. They're not very big. Each of those is a self-governing municipality. It can meet the criteria of being a self-governing jurisdiction. And that's where you're supposed to register to vote. Not to vote, you register as an elector. Hang on just a second. Yes, as I was saying, your school district can be local government, and you can be put into bankruptcy under Chapter 11. This section empowers local government for which an emergency manager has appointed to become a debtor under Title 11 of the United States Code. And actually, at the local level, the government is the people. I think they were saying this is how they made us debtors in Chapter 11. By putting the local governments in debt, and that's as simple as by not having the treasurer pay the bills. We'll get into more of that later. But anyways, this is kind of where we're headed with all this. And let's see what we got here. So, earlier this week I got sent this letter from John Miser in Minnesota. Minnesota High Court to consider judge's oath. Frustrated with his divorce case, John Miser turned to the tables on the judge. He now faces a review by the Minnesota Supreme Court over whether she took the required oath of office. Scott County District Judge Lennon said through court official that she did. Miser believes that he has proof that she didn't, and took his evidence to the Attorney General, the Governor, and the Legislature, the Court of Appeals, and the Supreme Court, which accepted the case even though the lower courts have already ruled in Lennon's favor. So he took it to many places. That Supreme Court wanted to be one of them, and they decided to look into it. It's a massive cover-up. The law is very clear, said Miser, which it is, and every case she touched is tainted, which it is. Anyways, not to read the whole letter. If you want to read this, though, it's easy enough to find. Just Google Minnesota High Court to consider judge's oath. It's an article by Brandon Stahl of the Star Tribune, updated on March 3rd, 2014. State law requires judges to take an oath before entering the duties of the office and file the oath with the Secretary of State. If the judge refuses to or neglects to take an oath, the office is vacated. I bet you there is a statute that says that. Clark signed his oath. After, according to the Secretary of State, only 2 of the 109 judges elected in 2010 did not file their oaths in 2011. Lennon and Goodhue. County Judge Lawrence Clark. Clark signed his oath January 3rd, 2011, but it wasn't filed until February 13th, 2013. Well, how could that be? How could it be that he signed his oath and it didn't get filed until 2 years later? Interesting. After Lennon declined to recuse herself a second time, Miser and McDonald petitioned the Chief Judge of the First District Court, Edward Lynch, to remove Lennon from the divorce case. He denied the request in February 2013. Lynch wrote that the state cases from 1915 to 1955 established that any judge who fails to file an oath of office, but who is otherwise lawfully acting under color of known appointment of election is a de facto judge. Yeah, he's a fake judge. He's not de jure, he's de facto. Yeah, he's not good enough for me, judge. Any judge who fails to file an oath of office, but who is otherwise lawfully acting under color of known appointment. Okay, so lawfully acting under color of appointment. So what does that mean? Well, what if you're allowing perjury to happen in your court, Judge? Is that lawfully acting? Right? What if you're allowing somebody to bring a fictitious plaintiff in to take somebody's property? Is that lawfully acting? I don't believe it is. I don't believe that any judge is lawfully acting in the courtroom. I believe you're a bunch of frickin' concealers. And it's time that you were judged. But that ain't up to me. It's the man upstairs going to judge your ass. The Supreme Court agreed to review Miser's case within the next month, but will take no testimony until it has ruled in another case involving whether somebody else had authority to preside over cases despite living outside her district. In other words, right, was she a registered elector within the district that she was a judge in? Apparently not. So here's my problem with this. I mean, it's great that the Supreme Court's going to look at it, but, you know, we're going to see the law is very clear. We don't need the court to sit and chat and decide again about what the law says. The law says you haven't done these things, you vacated the office. We need somebody to execute the law, not to interpret the law. It's already been interpreted. It's as clear as mud. Because now I'm going to use Michigan stuff because I'm more familiar with it. Vacancies, right? Every office shall become vacant on the happening of any of the following events before the expiration of the term of such office. Well, it could be death, resignation. He could put in a piece of paper, like it said in the other one, that, hey, I'm not taking the office, I resign. Even though I was elected, I resign. His removal from office for any other reason, right, by a competent court because he isn't a registered elector or has some other defect. Ceasing to be an inhabitant of the state, or if office is local or district, county, township, city shall be appointed or within such duties if his office are required to be discharged. All right, he's not a qualified registered elector within the jurisdiction that he took the office for. His conviction of any infamous crime or any offense involving a violation of his oath of office. Well, they do that all the time. The decision of a competent tribunal declaring void his appointment or his refusal or neglect to take his oath of office or to give or renew any official bond or deposit such oath or bond in the manner within the time prescribed by law. If he hasn't done it, he has vacated the office. We don't need it interpreted. We need it executed. Vacancies in certain county offices, temporary appointment. When at any time there shall be in either of the offices of the county clerk or prosecuting attorney no officer duly authorized to execute the duties thereof, the judge of the circuit court or the circuit in which the county where such vacancy exists shall be situated may appoint some suitable person to perform the duties of either said officers for the time being and when at the time that shall be in. Okay, the judge of the circuit court or of the circuit in which the county where the vacancy exists. So the judge of the circuit court of the county, which is different than the 15th Judicial Circuit, or pick some other number. It's the judge of the circuit court of the county. In the circuit court for the county of Kent, in Chancery, that court. In the circuit court for the county. Whoever that judge is can appoint somebody to fill the office. And when at time there shall be in either of the offices of sheriff, coroner, register of deeds, or surveyor, no duly authorized to execute the duties thereof, some suitable person may be appointed by the county clerk and prosecuting attorney of the county to perform the duties either said office being for the time being. Now, the interesting thing about this is it's written different ways, different places, and what it really sounds like is if there's a problem with the county clerk, they got a legal defect, such as they weren't a qualified registered elector, they put in a resignation, whatever, that it's the judges that are going to appoint themselves to fill the offices. And so pretty soon all these major offices are just filled by judges. You got somebody else running around that looks like they're holding that office, but they're really not holding the office. And this thing here, either of the offices of, right? Usually it's either or, right? And there is an or in here, so either or. So either of the offices of sheriff, coroner, register of deeds, like that's one office. And it could be because a coroner can be a sheriff, although a sheriff can't be a coroner. The coroner can take the office of the sheriff. And the register of deeds isn't necessarily the all capital letter register of deeds. It's the de jure register of deeds, where all the, important paperwork is, the proof in the recorder's office. Or the county surveyor. Like, that's a different office. All right. They can be appointed by the county clerk and prosecuting attorney of the county. I kind of think what happens is, when this is all said and done, that because when you read that the chief judge of the circuit court, he is the frickin' court administrator of the court. He's in charge of the administration of the court. He's the court administrator. He's actually acting as the clerk. And the prosecuting attorney, as we're going to see, is actually, looks to me like it's the register of probate. So, but anyways, that if there's a vacancy, like they neglect to take the oath or to give or renew the official bond, doesn't matter if whatever the reason is, the office is vacated. Period. Execute the law. We don't need to talk about it. We need it executed. Who's going to execute that law for us? Removals from office. Vacancy appointee, removal by governor. So the governor can remove people. Inquiry by attorney general or prosecutor. But who's the prosecutor? Right? Depends. So we need to figure out who's the prosecutor. Whoever it is going to conduct an inquiry into the charges made, shall thereupon give at least 8 days' notice to the officer accused, proceed by an examination of witnesses in relation to such charge before some circuit court commissioner, we don't have those anymore, or judge of probate, which we do have, or any judge of probate who may be appointed by the governor for such purposes, and he shall also, at the time of giving such notice, serve upon the officer accused a copy of the charges. Upon application of the accused officer, commissioner, probate judge shall require endorsement of witnesses on the charges. Going to have to sign your name. In the case, manner, and subject in the case rules law as to required in criminal cases. We're going to handle it like it's a criminal matter. In proceedings under this act originated by complaint filed by a grand juror acting pursuant to some other section, blah, 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 blah. Now, what is a grand juror? When you have a grand jury together, they're the judge. And then the judge is just there as an administrator, ministerial duties to execute the law as determined by the judge. And the judge was the grand jury. So the grand jury could be the judge of probate, the judge of the proof. Right? Because you give them probable cause, they look and say, hey, you got the proof, boom, execute the law. The Attorney General or prosecuting attorney may issue subpoenas, okay, and such commissioner or judge of probate shall have the same power to enforce obedience to such subpoena by attachment. In other words, he can put you in jail. At the time, place, specified notice, commissioner or judge probate for whom such inquiry shall be conducted. So, who's the court of inquisition? The judge of probate. Those who follow along, we've already known this stuff before. We had a guy here in Michigan a couple years ago who just emailed the probate court and said, are you the court of inquiry? And they said, yes. One word answer, yes. Jason down in Georgia went to the court of probate because the register of deeds or county recorder, whatever they're called down in Georgia, tore apart his public record where he was trying to accept the deed and had gotten the certificate of authority for the notary, and it was a public record. It had court seal on it. And she tore it apart. He went to probate. And they took his complaint. Don't ever know what happened with it because the complaint was she tore apart the public record, which may be different than, right? She's not really an officer, so she's usurping an office because she hasn't filed the correct oath and bond, so she's really not holding the office. So she's a usurper of an office and part of a insurrection. Handle that one, Judge. I'll sign to it. A commissioner or judge probate shall observe the rules of evidence as in chancery cases. Now we're in the chancery court. We are in the court of proof. Because in chancery, accusations are made and they're substantiated with proof. And the one who judges the proof, substantiates the accusation, is the judge of proof, judge of probate. Because probate means proof. And shall have shall have authority to rule on questions of procedural law. Right? So let's think about this. Well, who are these officers? Well, one thing is an attorney within the county is an officer of the court of the county. He is an officer of the court. So you should be able to bring a complaint to this judge of probate about this officer of the court, who by the rules of chancery cases will investigate. And the question is he in contempt of court because he, being the attorney because they sued in the name of a fictitious plaintiff, or oh God, just drew a blank. There should be 100 reasons to just pop off my head of why you could say the guy's in contempt of court. One thing is, I hope we get to this, and I'm sure we will, but I don't want to be too late in the video where people start falling asleep. All attorneys, I believe, are notaries. When Roe went with Broen, her friend, and they went to his attorney's office for his foreclosure, she saw some papers where he had signed it as a notary, and she questioned him on it, and the guy said, oh yeah, I said all attorneys are notaries, blah, 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 blah. Well, when you read the rules of what a notary cannot do, a notary cannot have another interest in the transaction. So in other words, since this attorney was Broen's attorney, he couldn't sign any paperwork as a notary. It's a conflict of interest. Well, if you have a complaint against a notary, you take it to the Secretary of State. So you don't make it against the attorney, you make it against the notary, because as a notary, he had a conflict of interest of being the attorney. That's one thing he could do, but he's also, because he's a notary, he is a officer of the court within the county. And so this judge of probate can look at whatever your complaint is to say, yeah, this guy isn't following the procedures of the civil procedures of court as he's supposed to. Now, if they're not going to follow the civil procedures or the criminal procedures, which is possible under one condition, that we're under the Lieber Code. In the Lieber Code, they can suspend the criminal code and the civil code. And then they leave behind people to hold these offices. But if they use their office for private gain, they're guilty of insurrection. In which case, you should be able to take insurrection to the county emergency manager, because he's responsible for all man-made disasters. And that certainly is a man-made disaster. Charges against prosecuting attorney, courts of record, jurisdiction over prosecution upon information. The several circuit courts of this state, recorder's court, any court of record having jurisdiction in criminal cases shall possess, may exercise the same powers, jurisdiction to hear, determine, prosecute upon information for crimes, misdemeanors, or all offenses. Issue rents of process and to do blah, 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 blah. Your mother was an informant. She gave an information to somebody. What Bobby found out in Arizona, and this will be on the next video, back in the day, your mother would, if she was an unwed mother, would open up a case against the father of the child. But if she decided not to pursue it, then the county commissioners would pick it up and they would pursue it. Right? And so your dad doesn't show up on your record of birth, it's just your mother does. And they put it in into a legal newspaper about your birth. All that stuff comes up. And so even though your mother didn't pursue the case, the county did, and they opened up this case. And that's what that record is, of your live birth record. It's record of a court case. Alright, which one was that? That was number 3. What can the chief judge of probate do? Right, because we're talking about this, if there's any of these actions, they go to the chief judge of probate. He's the one that a case goes to for a vacated office. Chief judge of probate of a county may designate one or more places in the county where regular sessions of probate court may be held. Now that's interesting, because way back when, a couple years ago, they told Rich up in Alpena, when he called trying to collect his claiming his birthright, his estate, the probate judge says, well, it sounds like you need to have an informal status hearing. Do you want to have it on-site or off-site? At the time, Rich didn't know which one he wanted to do, so he didn't do either. It's one of those things that has just fallen through the cracks, and he's never done anything with it since, but it's what was said at the time. A designation made on this subsection may be delivered to the county clerk. Nothing in this section prohibits a judge from holding a hearing regarding an allegedly incapacitated individual or an allegedly mentally ill person at a site considered appropriate by the court as provided in something of a state's and protected individual code, on-site or off-site. All right, I'm not a protected individual. I'm not incapacitated. Go ahead, ask me a question. All right, don't slander my God-given character. When a probate judge or other county or probate court district is performed duties under these sections, he or she shall receive additional salary and reimbursement. Okay, so you get some extra money for doing these things. The probate judges of a county having 2 or more probate judges shall have equal powers, duties, and compensation. See, that's where it says 2 or more probate judges, right? Because I haven't looked to see how many counties might have more than 2, but I'm thinking that the grand jury are probate judges. Judges of proof. Could be more than 2. But forgetting that part for right now, we'll just go with what we think are probate judges. Except that the power of nomination, 2 or more judges shall have equal powers, except that the power of nomination, appointment, and removal of the several employees, right, removal of office, as provided by law for the probate court in that county and of the offices connected therewith, and the general direction and control of the business of the court, including the divisional work between the blah, 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 right, that's going to go to the chief judge, to the chief probate judge selected as follows. If the county has less than 1 million people, then in the probate judge having served the longest period continuously, if 2 or more judges were elected at the same time, same election, 2 or more, it just amazes me, 2 or more judges, probate judges. Right, because that's in a county less than 1 million people. In a county that has 1 million or more people, when the probate judge of that county is selected by the governor. Right, so if you got more than 1 million people, the governor is going to select the probate judge. If it's less than 1 million people, then the guy that's been there the longest. But how many probate judges are there? Well, this is good. In each county, the probate judge of the county or probate court district, or the chief probate judge in a county having 2 or more probate judges, may appoint a probate register at reasonable salary fixed by the county board of commissioners. I'm going to have to file a bond and an oath, of course, with the clerk, the county clerk of the county. That would be good to get, of the probate register. If a county has a probate register, the probate judge or chief probate judge may appoint 1 or more deputies. Okay, they're going to have the same powers. Yeah, okay. Probate register or deputy probate register powers in uncontested matters or hearing. Entry of judgment prohibited, restriction on powers, orders, acts, blah, 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 blah. Okay, so what can these people do? What can the registrar do? Determine whether the petitioner or the petitioner's attorney has complied with requirements of law and Supreme Court rules. Bingo. Has the attorney for the other side complied with the rules? That's why you're supposed to, if you have a complaint against an attorney, you bring it to the circuit court of the county, and the circuit court of the county, the probate registrar, I think, is the prosecuting attorney. Determine whether the petitioner or the petitioner's attorney has complied with the requirements of law and Supreme Court rules. They can also take acknowledgments, administer oaths, set hearings, sign notices, citations, and subpoenas. Take testimony required by law or Supreme Court rule in all the following matters. Appoint a fiduciary. Determination of errors. Blah, 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 blah. Removal of fiduciaries. Well, now it just depends on what the definition of a fiduciary is. Right? They can take the testimony required by law or Supreme Court rules in all the following matters. Removal of fiduciaries. Fiduciary. Fiduciary gives rise to certain Legal incidents and obligations. The term is not restricted to technical or express trust, but includes all other offices or relations as those an attorney at law, a guardian, an executor, a broker, a director of a corporation, and a public officer is a fiduciary. And the probate registrar in Michigan can take the testimony required by law in all the following matters to remove a fiduciary from their office. You don't take it to the Supreme Court, your complaint, you take it to the probate court. At least in Michigan, we'll have to figure out what it is called. Other places, it'll be the same thing. And it's the probate registrar that can take the testimony. As it turns out, they call probate, although every county in Michigan has a probate court, they call it a probate district. Each county is a district. This is the district court, lowercase district court, that in the Michigan compiled law says you can go to the district court and with your complaint, and the clerk or the assistant clerk will write your complaint for you. You can give it to them over the phone. There's all sorts of things. It's kept talking about this lowercase district court. And it's the probate court that's a district. It's the constitutional district court. But I can't, again, determine whether the petitioner or the petitioner's attorney has complied with the requirements of law and Supreme Court rules. Except as provided. Okay, so that's the petitioner. What about the respondent? Determine whether the petitioner or petitioner's attorney has complied with the requirements of law and Supreme Court rules. Okay, that's where it talked about if you had a complaint against the you're the client of an attorney, you could bring the question to him. But you can also have it done to remove a fiduciary. Well, it says in here, attorneys at law are fiduciaries. Well, it's in the definition of what it is. Those or relations as those of attorney at law, a guardian, an executor, a broker, a director of a corporation, and a public officer. Right? Writ of quo warranto can be issued out of this office. Issue a license to marry. Well, they'll issue a license for underage children to get married if the parents agree with it. It doesn't necessarily mean they're both underage children. It could be one of these Jewish marriages where some old man wants to marry a 3-year-old girl. As long as the parents agree, they'll go ahead and issue the license. Talmudic law. Nothing wrong with having a 3-year-old wife. For appointment of a guardian or of a legally incapacitated individual, or the appointment of a conservator for a reason other than minority. Right? So we could have a conservator right now. We could have because we're legally incapacitated. Right? It says legally incapacitated, right? It didn't say mentally, legally incapacitated. How can you be legally incapacitated? It's because you're not registered as a qualified elector within your municipality. And you're walking around in the judge's eyes, myself, I'm Rytlewski, Robert Allen. Right? They don't know what my real name is. It's tucked away in an envelope inside of an adoption hearing that was part of this fiasco that went on way back when. And they gave me a fictitious name for the court record, Rytlewski, Robert Allen. An order made by a probate registrar or deputy probate registrar shall be made over the name of the probate judge for whom the order is made. The probate registrar or deputy probate registrar shall place his or her signature under the name of the judge. Okay? Court reporters, I don't know, that was important. If I didn't highlight it, I ain't going to read it. Too much to read. Official bonds, certificate of filing. When any civil officer appointed by the governor, Senate, or governor with the advice and consent of the Senate of the state is required by law to give a bond and to file the same with another officer than the Secretary of State. Okay, so if you're a state officer appointed by the governor, this would be like that probate judge, right? Got appointed by the governor, and whoever else. He shall procure the certificate of such officer that such bond has been duly filed with him, and file the same with the Secretary of State. Okay, so you're an officer, and you're supposed to file your shit with somebody other than the Secretary of State. Well, once you've filed it there, you're going to get the certificate of that officer, like the county clerk, and then you're going to file that with the Secretary of State. So the Secretary of State should know who's been appointed to any office anywhere in the state. If it's somebody who was appointed by the governor or the Senate or by the governor with the advice and consent of the Senate. Sound like judges to me. Official bonds placed in filing. When any such officer is required by law to give a bond for the faithful performance of the duties of his office, and no provision made in law for filing the same any particular office, such bond shall be filed with the Secretary of State. Official oaths and certificates of bonds. Every officer, except those otherwise directed by law, shall file his oath of office and also, besides the oath of office and the certificate or bond aforesaid, as the case may be, within 60 days from receiving his commission or appointment. And in default thereof, such commission or appointment shall be null and void. All right, so if you're appointed to an office by the governor, well, then it should be with either your appointment is with the county clerk or some local office like that, or it's with the Secretary of State. But there should be some kind of certificate for it. All right, certificate of commission, certificate of appointment. That's the other piece of paper to look for besides the oath is, okay, well, now they have a certificate for their commission. They got a certificate for their appointment. And this came up with Brother West down in Indiana, where he went down to the Secretary of State and they handed him an oath and a certificate, but they weren't attached to each other. And so then there was something strange about they not only being attached, but both of them being with the Secretary of State. And we're going to look at that. We're going to get to his Indiana stuff here in just a second. Prosecuting attorney. The person so appointed shall, before entering the duties of his office within 20 calendar days of receiving notice of his appointment. So there's a notice of appointment. Where's the notice of appointment? Appear before the county clerk and take and subscribe the oath of office prescribed by the Constitution. So the county clerk should have the notice of appointment for the prosecuting attorney, who shall thereupon deliver to the person so appointed the commission received by him for such person. Well, okay, so you're going to get a notice of appointment, and then you're going to come and take your oath, and you're going to get a certificate of commission for the appointment. This isn't that much different than it is for a notary, right? You get apparently they get an appointment, they get something from the government, certificate of some kind. Now, Jerry here in Michigan, he went down last week and tried to get a copy of the commission for the prosecuting attorney, and the person that we would think of as the county clerk wouldn't give it to him. Said, you need to go to administration for that. What did they mean by that? Did they mean the county board administration, or did they mean the court administrator being the chief judge of the court as the administrator, because he's administering the court? That's what we got to find out. But they didn't want to give him, because once you know who the prosecuting attorney is, right? the point is, it don't seem to be the guy that says prosecuting attorney. It's somebody else. That guy's got a defect. Somebody's filling his job. When you find that person, which I believe it to be the probate registrar for the reasons that we just went through, what their functions are, taking testimony and so forth, that you'll know where to take your complaint to. And again, it said in Michigan, you take your complaint to the district court. And when you got there, that the district court clerk or the deputy clerk would take your complaint. Right? In fact, they would write your complaint for you. You just have to sign it. Well, I've tried taking complaints to 7 or 8 different district courts, or 7 or 8 different complaints to district courts, but they were the ones here in Michigan that say district court. It's that wordplay thing. It wasn't the right court. Crime victims compensation. No, not that right now. Yes, save that. Each of the officers named in this chapter receive an official notice of his election. Again, there's some kind of official notice of election. Shall take and subscribe the oath of office prescribed by the Constitution of the state. Deposit the same of the clerk of the proper county, who shall file and preserve the same in his office. Right? So first of all, who sent him the notice? I want to see a copy of the notice of election. And was there a notice sent to the Secretary of State that for any reason it was sent after they did the paperwork from the state canvassing board? Oops, too late, missed it by a day. Hey, I'm not taking the office, but thanks for the paper. I'll just go ahead and hang it on my wall anyways. Although I've already given you the paper that says I'm not taking the office. Or there's a defect. I can't have the office. County officers. Each officer required by a county board of commissioners. Right? So now we're talking about the county board of commissioners. Shall deposit the bond with the treasurer. Okay. So it's the county board of commissioners that says who has to file a bond and that they get filed with the treasurer. And I think it goes on to say except the treasurer's, his gets filed with the clerk of the county. County board of commissioners. County officer neglect to deposit oath or bond if either of the said officers shall neglect to deposit his oath or bond in accordance with provisions of the 2 last preceding sections, 120, 119, 118, except notaries and prosecuting attorneys. See, uses the word each. That throws me. Or if either of the said officers shall neglect to deposit his oath or bond according to the provisions of the 2 preceding sections without giving notice specified in the next section, or if he shall enter upon the execution of his office before he shall have so deposited said oath or bond, he shall in either case forfeit pay of $100. Okay. If either of the said officers and see, the only thing I see here is in each of the officers named in this chapter except the notary public and the prosecuting attorney shall before entering upon duties of his office within 20 days receive an official notice, or 20 days commencement of the term. Right? So even if he hasn't gotten an official notice, right, 20 days after the commencement of the term, you just go down and take the oath, even though you didn't get the piece of paper that says you're holding the office. You're just de facto. You just walked in, right? It's a vacated office, and you're going to go sit in the chair. No penalty shall attach on account of any neglect to deposit such oath or bond as for said in any case such officer before entering upon executing of his office and within the time limited for filing such oath or bond, shall give notice in writing to the officer or officers having power by law to order an election to fill such office or to fill the same by appointment, stating therein that he declines accepting such office. No penalty shall attach on any account of any neglected deposit, the oath or bond, in case such officer, before entering upon the execution, so he's going to enter the execution of his office anyways, even though he's going to file a piece of paper saying he declines accepting such office. He's just going to go sit in the chair. Shall give notice in writing to the officer or officers having the power by law to order an election to fill such office or to fill the same by appointment. Okay, so we got to figure out who these people are. Who is it that can order an election, and who is it that can fill the same by appointment? Well, the one that can fill the same by appointment is judge of probate. I don't know who can order an election, but I'm going to say it's probably the judge of probate, who can order a special election to fill a vacancy. And see if they have been given notice in writing from any of the officers who are now sitting in the office that they declined to hold the office. Whenever the governor shall appoint a prosecuting attorney, the Secretary of State shall transmit his commission to the clerk of the county for which the prosecuting attorney was appointed. And the county clerk, on receiving such commission, shall immediately give notice thereof to the person who was appointed. So again, the county clerk knows who was commissioned by the governor, right? Or the Secretary of State can tell you who the prosecuting attorney is for your county, because that's where it's coming from. The governor appoints, the Secretary of State transmits the commission. The clerk of the county gives the commission to the person appointed. You want to know who the prosecutor is? Call the Secretary of State. Who got the commission as the prosecutor for this county? Prosecuting attorney, oath of office, filing, delivery of commission. The person so appointed shall, before entering upon the duties of his office, and within 20 days after receiving notice of his appointment, right, appear before the county clerk and take the subscribed oath of office prescribed by the Constitution, and file the same with the clerk, who shall thereupon deliver to the person so appointed the commission received by him for such person, and shall thereupon give notice to the Secretary of State of the filing of such oath and of the time the filing the same. So Secretary of State knows who's the prosecutor attorney is for every county, and did they accept their oath or not, or did they accept the office? Shall thereupon give notice to the Secretary of State of the filing of such oath and of the time of filing the same. Go to the Secretary of State to find out if they've accepted the oath. If they have, who is it? That's the person you go to, because it's the prosecuting attorney that can take an information and file with the court for a writ of quo warranto, which is a writ of by what authority does somebody bring a charge against you, or has somebody usurped the office or violated the charter of a corporation, such as a municipal corporation. So in other words, the county of Kent is different than Kent County. Kent County is the corporate. County of Kent is the de jure. Is Kent County in violation of their charter because of the actions they're doing today by stealing people's property? I'd say yes. Who do you take the complaint to? I need to get a writ of quo warranto. The public to the prosecutor, prosecuting attorney. But who is he? He's the one, forget the name, he's the one that the Secretary of State has got a frickin' notice from that he filed his oath. And the Secretary of State's the one that sent him his commission. That's beautiful stuff. Well, that's what it says in Indiana. This is, for something a little bit different, right? So, officers and deputies, prosecuting attorneys and their deputies, except as provided in this section, every officer and every deputy, before entering office, shall take the oath, support the Constitution, faithfully discharge duties of office. A prosecuting attorney and deputy prosecuting attorney shall take the oath required under Section A before taking office. Right? So they need to take an oath. We'll see why this is important in a minute, because John in Minnesota, again we're looking at Indiana, but John in Minnesota sent me a bunch of oaths today that he got all of them. And the deputies, they don't swear, they just declare and promise, but it doesn't say that they swear. Shall take an oath to support the Constitution, faithfully discharge duties of such office. Okay. This subsection applies to deputy of political subdivision, individual appointed by a deputy in considered an employee, performing ministerial functions on behalf of the state, is not required to take an oath prescribed in this section. An individual appointed as a deputy in consideration is considered an employee of a political subdivision performing ministerial functions on behalf. Okay, that's in a political subdivision. This subsection applies to a deputy of a political subdivision. An individual appointed as a deputy is considered an employee of the political subdivision, performing ministerial functions on behalf of an officer, and is not required to take an oath prescribed in Section A. However, if a chief deputy assumes the duties of an office during a vacancy, the chief deputy must take an oath required in the subsection before entering the duties. Okay, so it sounds to me like they're saying, except for the prosecuting and deputy prosecuting attorney shall take an oath, right? That other deputies don't have to take an oath. They're just performing ministerial functions under the officer, who's now responsible for their actions. Except the chief deputy. And this is where it says, this is about the chief deputy is taken. See, the chief deputy doesn't get elected. He always sits there. He's elected. The officers go in and out, in and out, in and out. They're going to have some kind of legal defect. It's all been set up ahead of time. They're not really going to hold the office. The powers of the office are going to be given to the chief deputy. They're going to assume the office during a vacancy. Okay. Individual appointment or elected officer subdivision does not comply, the office becomes vacant. Section 2. Except in cases of a notary public, in those cases specified in 3 of this chapter, shall be endorsed on or attached to the. Okay, so the oath required by Section 1 of this chapter, except in the case of a notary, or in those cases specified in Section 3 of this chapter, which is coming up, shall be endorsed on or attached to the, right? So the commission's either going to be attached or part of the oath on a certificate of appointment, oath of office of prosecuting attorney, attached to the commission of the prosecuting attorney. So the oath by itself isn't enough. It's supposed to be attached to another piece of paper. Okay, now they said except for 3. Members of the General Assembly, and their oath is entered into a journal of some kind, and the governor or lieutenant governor. Anybody but that, that's it. That's all there is. So anybody other than that, the oath is supposed to be attached to another document, a commission, a certificate of appointment. That's about it. These are your 3 choices. As using the subsection political subdivision means a municipal corporation or special taxing district. That's what that means. The copy of the oath under Section 2 of this chapter shall be deposited by the person as follows. Of all officers whose oath is endorsed on or attached to the commission, it's either endorsed on the commission as part of the commission or it's attached to the commission, and whose duties are not limited to a particular county, or of a justice, judge, prosecuting attorney in the office of the Secretary of State. Right? So a copy of the oath shall be deposited with the Secretary of State along with the commission of the circuit court clerk, officers of a political subdivision or school corporation, and constables of small claims courts in the circuit court's clerk's office. And again, that's going to be a copy of the oath and the commission of the county containing the greatest percentage of the population, political subdivision, or school corporation, of a deputy prosecuting attorney in the office of the clerk of the circuit court of the county in which the deputy prosecuting attorney resides or serves. Deputy prosecuting attorney in Indiana. We got one of those to look at. So a copy of the oath under Section 2. Let's go back to Section 2. That says a copy of the oath shall be endorsed on or attached to the commission, the certificate of appointment, or the certificate of a certificate was issued under. I didn't go look those up, but the oath by itself ain't enough. We'll have something to look at here in just a minute. Political subdivision excludes any department or agency of the state. Required by Section 18 of the statute to file an official bond, faithful performance duties. Shall file bond in the office of the county recorder. And again, this is lowercase county recorder. This is the same as the lowercase register of deeds. This is a judge. It's not that frickin' room you walk into that says county recorder over it. The county recorder and the deputies employees of the recorder shall file their bonds in the office of the clerk of the circuit court. So go to the clerk of the circuit court and ask for the bonds of the county recorder. That's how we're going to find out who these people are, right? We're going to go trace down their paperwork. Either from the Secretary of State to make sure they got the certificates they're supposed to have, because the oath by itself isn't enough. But if they haven't filed their oath, they've vacated their office, and we don't need to go to the Supreme Court to have them decide, hey, what does this law mean? No, the law says if you didn't file your frickin' oath on time, you vacated the office. We need the law executed. Who can execute the law? The prosecutor and attorney with the probate judge. Because he's been given special powers, at least here in Michigan, from the governor for removal of people from office. Oh, every county officer who is required to give a bond shall have a copy of the oath of office recorded with the bond. Right? Wherever the oath is where the bond is. The official bond of the Secretary of State shall be filed with the recorder's office of Marion County. Preservation of certified copies. It shall be the duty of every officer with whom such certified copies and bonds shall be filed to preserve the same, and on demand give certified copies thereof, or of the record attested with his official seal, and for the same he shall receive the same fees allowed by law for certified copies in other cases. Right? And if they're not going to follow this, then it's time to have them removed from office. And if they're not going to tell us who the prosecuting attorney is or where we go to file our complaint against an officer for violating their oath, their duties of their office, then you go to the county emergency manager because it's an insurrection. The official bonds of officers, if sufficient, shall be provided as follows. The county officer is required to give bonds by the clerk of the circuit court unless otherwise specified in the section. Right, so the clerk of the circuit court, county sheriff, county coroner, of county officers required to give bonds by the clerk of the circuit court unless otherwise specified in this section. So the county officer, county coroner, county recorder, county auditor, county treasurer, clerk of the circuit court, by the county executive. He's the one that's going to okay the bond, approve it. Of the county assessor, township trustee, township assessor, if any, the county auditor. City executive. a person who approves an official bond. So not only do they have to have an official bond, now it has to be approved. It has to be a person who approves an official bond shall write the approval on the bond. Not only do you got to find the bond, then you got to make sure that somebody wrote on there that the bond's been approved. I mean, if they haven't done these things, they haven't followed the law. An officer required to give an official bond shall give the bond before commencement of his term of office. An officer bond shall be payable to the state of Indiana. No official bond shall be void because of defects in form or substance or in the approval of filing thereof, but upon suggestion of the defects, such bond shall be obligatory if properly executed, filed, and approved. So no official bond shall be void because of defects in form or substance or in the approval and filing. So if they haven't done these things, it doesn't matter. But on suggestion of such defects, like, hey, they didn't file their bond, such bond shall be obligatory as if properly executed, filed, and approved. So you don't have to find their bond. You have to say, hey, that they haven't filed it, I'm still attaching to their bond, and take the complaint to the right office. The public prosecutor or the prosecuting attorney, as the probate registrar, I'm believing that's the one that can remove a fiduciary. Find out who can remove a fiduciary in your county, and that's who you take your complaint to. That's what I believe. The official bonds of a county surveyor and township trustee shall be executed by the principal and two or more freehold sureties. Look, we got freeholders. Here they are. They showed up. Indiana. The official bonds of the county surveyors and the township trustees shall be executed by the principal and by two or more freehold sureties or an authorized surety company. I wonder which one that'll be. See, I think that we should all have a bond filed. In fact, I think where it says you have the right to bear arms, they're talking about you have the right to become a notary. And when you become a notary, you work under the great seal of the state, which is the coat of arms of the state. And you file a bond. I don't know. All sorts of things to check out. Man, I got time to read that. There's too many things here. Let's see what this is. Okay, this is the complaint that John put in about the judge up in Minnesota that's now with the Minnesota Supreme Court. Failed to take an oath and vacated their office according to these statutes here. She forfeited her office. So, John, what you want to do is you want to find out which office, who can remove a fiduciary. I'm almost positive it's going to be the probate registrar. You just need to find out, where do I put a complaint in against an officer from the county? Right? And you go in and say she has not. She's a fiduciary, got a fiduciary duty. We don't need the Supreme Court to interpret the law. It's already been interpreted. We need the judge of the county, the sheriff of the county, to execute the law. The English sheriff. So anyways, after this happened, this is what she put in. Right? Now I know that, people like to have their ideas about the boxes. So here's a perfect example. Right? These boxes aren't attached to each other. So she didn't subscribe this before this people in the box in the bottom, right? This hasn't really been done. In my opinion, they're in separate boxes. Right? But the other thing is, does she have a certificate of election? Right? So she have these certificates you're supposed to have that go with the office. compared to these. Now here's some more that John sent me. Let's take a look here. I'll go this way. Certificate of election and official oath of somebody, right? I see the oath. This is the certificate of election and official oath of Kevin somebody, the county sheriff. All right, there's the oath. Where is the certificate of election? Right, and this is supposed to be subscribed under her hand and seal, and I don't see that it is. Here's another one, certificate of election and official oath of. So unless it's on the other side of the paper, where is the certificate of election? The two have to be together. And this is just the oath. All right, here's the oath. This oath doesn't have any seal on it. Subscribed and sworn before me someday, Judge somebody, Scott County, Minnesota. Where is your frickin' seal, Judge? Right, because a lot of these say if it's other than a notary, it's supposed to do something. Okay, so here we're going to keep looking, right? Certificate of election. So I don't see any of these that have a certificate of election. Certificate of election. Certificate of election. Where is the certificate of election? Certificate of election. I don't believe anybody's done this right now. Again, unless this is on the other side of the paper, but where is it? And it has to be subscribed and sworn to by the election supervisor or whoever the heck it is. Okay, and then we got this one here. Rotate view. Go back this way. And this is all the deputies. Deputy auditor, treasurer, deputy auditor, treasurer. Look at all these deputy. Cindy here, she's not a deputy. She is the auditor, treasurer. All the rest of these are deputies except for Cindy. That's interesting. How come Cindy is right? And so here, these people, now this is the difference, right? Shoot. Let me go back to this one. This one here, you put your name in there, fill it out, right? That's different than this. This is state your name. This is like they do in the military. You stand there and you're taking this oath as they're reading it to you. Where this is just an instrument that you're filling out to say you've taken an oath and handing it to somebody. Where this is being administered an oath, right? Somebody has given you this oath. And Cindy Geese is the auditor, treasurer of Scott County, the county of Scott. All right, that's the office you go to find, you go talk to Cindy about all the different frickin' bonds and stuff for all these other people. All right, so I state your name, do solemnly swear I support the Constitution of the United States of Minnesota, faithfully discharge the duties of the auditor and treasurer of Scott County to the best of my ability, so help me God. Subscribed and sworn before me on this date, 1999. See, they don't get elected. They just stay there forever. These deputies, they're not going anywhere as long as they're serving at the pleasure. But there's one of them here where it doesn't say deputy. It doesn't say deputy. It says the auditor treasurer is Cindy Geese. Record of appointment and oath. I, Pat, somebody hereby state I am appointing in writing somebody. Well, first of all, does Pat have the power to appoint? That's what we need to know. Can he appoint anybody to an office? He says he's the Scott County attorney. And he's going to appoint these people as assistant county attorneys. But does he have that power? Is he able to appoint anybody. I, Ingrid Dixon, do hereby declare and promise, right? They didn't swear to anything. It wasn't sworn before. It was declared and promised. I don't think it's the same thing. Why does it say sworn and affirmed? And you're here saying you declare and promise. I don't think you did it, Ingrid. I think that you're a little liar. Subscribe before me on this date. Okay. Document number. Blah, 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 blah. So it looks like it's the Office of the County Recorder, Scott County, Minnesota, certified and or recorded on 510 at, okay, so that would be May, okay. Janice From, acting county recorder. Everybody's acting. She's not the county recorder. No fee. Well, here's more of the same. But none of these have been recorded like this one has been. It's the only one that's been recorded. Okay. So why is this one, they have everything on the left-hand side. And for the same office, well, this is a special assistant county attorney. What was this one up here? Is this special assistant? No, this is just assistant, not a special assistant. These guys are special. They're so special, they're going to fill the paperwork out different. Seal on this side, name over here. It hasn't been recorded. This one has been recorded. Right? Is there anything about where your seal needs to go in comparison to the public's name? I don't know, but this one here has been recorded. These haven't been recorded. And again, I don't know that Pat here, old Pat, he has the power to appoint anybody. He's just a frickin' attorney. You know, I have to read it closer to find out. But as you can see, that's what's happened everywhere else on there. So just some examples of lies, cheats, and steals. Here's one for let's see here. Okay, this is in the matter of the office of prosecuting attorney. To all shall be these present greetings. Ye know ye that I, Curtis Somebody, have been duly elected prosecuting attorney, and by authority vested in me by the state of Indiana, do hereby commission and appoint. Again, does he really have the power to do this? But he says he does. A qualified deputy prosecuting attorney, made Shelley, in and for Elkhart County, beginning January 15th, 2013 to December 31st, 2013. Now, apparently this lady's involved in a as the prosecutor in a guy's case, but her oath is, you know, is passed. It was up December 31st, 2013. She doesn't have an oath anymore. But as the prosecuting attorney, I do solemnly swear. Now, the people of Minnesota, they said that they declare and promise. I do solemnly swear I will support the Constitution of the United States, the Constitution of the State of Indiana. I will faithfully and impartially discharge duties of something, Indiana, according to the best of my skills and abilities. So help me God. My commission expires, whatever, blah, 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 blah. But where's the frickin' seal? Curtis Somebody, prosecuting attorney, where's your seal, Curtis? Right? I think these oaths had to be under seal, don't they? There's some kind of file stamp here, but I don't see where it's been sealed. And it's past the time that she could do this, right? Because her office only lasted till December 31st, and yet she's in a traffic case against a guy right now in Indiana. She's in a vacated office. Fiduciary. Who can remove a fiduciary? That's who you need to go talk to. Who can remove the fiduciary? Now on there, just this is the certificate that came from the court clerk. Within the being the same court of record and seal, do hereby certify the above and foregoing a full, true, and complete and correct copy of the appointment of filed 1/16/13, yada yada yada, in the same remains and file in the office. Okay, so she's confirming that the lady's oath or her office has now been vacated because she hasn't filed a new oath. She hasn't been given any power from the attorney. If he had it before, he didn't do it again. So as of the 1st of 2014, she no longer had an office. She's usurping an office. In witness whereof I have hereunto set my hand and affixed the seal of the said county at the city of Goshen, Indiana. I don't see the seal. I had to take her word for it. Should be a seal right here. Right? Where's the seal? Affix the seal to court. I like to see it. But for Indiana, this is what you might want to pay attention to on this, is that the wording. Wendy Hudson is the clerk of the Elkhart Circuit Court within and for the county of Elkhart. Right? So if you were to make a petition, I believe the petition would be to the Elkhart Circuit Court within and for the county of Elkhart. That's the name of the court. Same being a court of record having a seal, do hereby certify that what we looked at is what's on file and it's no longer valid because it's after the 31st of December 2013. And this doesn't have no frickin' seal on it. Where is the court seal? Unless it's embossed, which it could be, and you can't see it, but I don't see it on there. Okay, some more to look at. We having fun yet? We're going to finish looking at these all, so I'm going to stop this video, and then I'll start a new video up after everybody's freshened up a bit. So, won't try to overload it in one video. This is Jerry Stanton here in Michigan, who's got a, first of all, before we look at the oaths, so I don't forget, he just got a judgment for a tax case. If anybody's gotten a judgment for a tax case in Michigan, any place else for that matter, just read the very first line in this case. Right? Judgment of foreclosure. This matter was initiated with the filing of a petition on or about June 1st, 2013. Period. You don't need to go any further. Either it was filed on June 1st, 2013, because if it was filed, it's got a fucking file stamp on it. Right? Where's the petition, Judge? Jerry's not seen this petition. I said, Jerry, go tell the judge, hey, I didn't see the petition. Show me the petition. Because on this petition, the petition identifies parcels of property forfeited to the Branch County Treasurer under some law for unpaid 2011 prior year's taxes set forth the amount of the delinquent taxes, interest, and penalties. If you can find this petition, it's going to tell you what general tax you owe. But they can't say on or about some day a petition was filed. When was the petition filed and what's the number? You need a more distinctive, determining, I don't know what the wording is they use for that. You need a better answer. All right, so Jerry, I think you should go to the judge and say, hey, Judge, I didn't get a copy of this petition. Or we're going to have to go to the probate judge and say, look, this says on or about. Either it was or it wasn't. Where is the petition? It had to have been filed. It got a file stamp. Right? Either it's been file stamped and entered into a book, or it doesn't exist. That's my point. But in all this, he went down and got some oaths too. And this is the first one he got for this. This says 15th Circuit Judge, Branch County. Well, that's the 15th Circuit. It's not the Circuit Court for the county of. It's the 15th Circuit. But as you can see here, there's nothing below that it was subscribed by anybody. But as we found out later, this is a piece of paper. See this black stripe here? They got the bottom covered. They're concealing the information. This is called concealment. It's a crime that's listed just below treason. Somebody's guilty of concealment. And then we had the county treasurer who took his on the 20th day of December. And again, I mean, is the bottom of his covered? What's missing here? It looks like they did the same with this. This is the county clerk, 19th of December. Now, it said in Texas on the last video I did that you can't take your oath before the first of the year. So we would have to go back because it said a little bit different in Michigan, but it depends on when they got noticed that they had been elected. And did they get all the other paperwork? Got a certificate of election? Okay. So, but it looks like on all of these, they've covered up the bottom half of the oath. Now, here's the individual bonds that are required. This tells you what each is required to pay. And then we got some blanket bonds. And they don't want to give these bonds to Jerry. But as we found out, one of those, see where it says county treasurer, well, we may think that she's the treasurer. What if she didn't actually take the office? And we just don't know she didn't take the office. How about this chief deputy treasurer? That's who I'd be talking to. I bet you that chief deputy treasurer is the treasurer. Well, then we went further, and so he went back again, and he got the same oath again for this P. William O'Grady. He's the 15th Judicial. But this is the interesting one. This is for a probate judge. And see, this has the bottom half, and, well, there's a seal here. Right? Somebody got a seal on theirs. Now, at first glance, if you're from Michigan, you say, oh, that's the Great Seal of the state of Michigan. Well, there's only one problem with it. On the right-hand side, the moose ain't looking the right direction. He's supposed to be facing the shield. He's looking over his shoulder. He must be from one of them counties where there aren't many women and all the sheep are nervous. Because he's looking over his shoulder. He ain't looking at the frickin' shield. It is not the... It's a counterfeit frickin' Great Seal. That's what it looks like to me, man. I mean, when you look at how this should look on this critter on the right, which is supposed to be a moose, got an elk on the left and a moose on the right. The moose is supposed to be facing the elk, and his nose wouldn't be hanging over the back of his, looking over his back. It'd be facing the frickin', basically the eagle and the elk. There's an eagle sitting up here. Elk here to the left, the Great Shield in the center, and he's looking over his back. It's a counterfeit. Doesn't exist. I don't know what county that's from or what state that's from, but that's not the Great Seal of the state of Michigan. This dude ain't holding an office, which is good to find out. He's not really the probate judge. Because P. William O'Grady, the circuit court judge, is the judge on this one here that nobody swore to. He didn't swear in front of anybody, right? There's the top half of his. Now look at this guy's. Same top half, but, you know, sworn and subscribed before me. Well, that's not on the guys above. And this seal is fucked up, man. That seal is not the Great Seal of the state of Michigan. That blows me away. Well, he went down one more time and said, no, I want a certified copy. So he got them to give, this time they gave him this copy. Same P. William O'Grady, 15th Circuit Court Judge. The third version of his oath. And now it has been filled out by some judge of the 3rd District Court, Branch County. Well, okay. Judge David T. Coyle, do you have a proper oath? Can you even do this? Where is the seal? I don't see no seal, man. And then we got a deputy treasurer, and a 15th Circuit Court judge, right? Here's the judge again. Now he's doing this kind of oath. What the fuck's going on here? The guy's got 4 different oaths. Well, actually, they're not 4 different oaths. It's just on the first one they didn't show the bottom, and this time they're showing the bottom of the same oath. My opinion, that's what this is. Now they're not concealing. They were concealing before. They're not now. I was for it before I was against it. Right? They had this part covered up before. If they're doing that in your paperwork, that's called concealment. You need to call them on it. Say, I want a true, because they put this on. This is what they put on, right? This is on the frickin' seal when they did it from the clerk's office. Original certified, official certified copy, original document on file. Well, that's what this one said. Official certified copy of original document on file. Yeah? Well, how come that ain't got no bottom on it and this one does? Looks like the same guy to me. Right? Somebody's lying. And now these people, see, they took their oath on the 2nd of January. 2nd of January. 2nd of January. They didn't take it on the 20th of December. They waited till after the 1st of the year to take their oath. I just think that's quite interesting, that there must be something to it. It's got a page number on it, 195. Well, this one's got a page number on it. Now, how come this one doesn't have a page number? And this one does. As you can see, there's all sorts of discrepancies that can be pointed out. See, this one's got a page number on it, 214. That one doesn't have a page number on it. Or maybe it's covered up. So, anyways, as you can see, got lots of, just real quick, filing of oaths and bonds of county officers. Take and subscribe the oath of office prescribed by the Constitution of the state before some officer authorized by law to administer oath, and deposit the same with the clerk of the proper county, who shall file and preserve the same in his office. Each officer required by a county board of commissioners. So the county board of commissioners determines who has to give an individual oath, and we saw who they were, except the treasurer shall deposit theirs with the treasurer. But the treasurer will deposit theirs with the clerk of the county. Not necessarily the county clerk, the clerk of the county. Neglect to deposit their oath or bond if either of said officers, okay, we read that before, don't really know what that means. Right? But they don't owe the money if they send a notice saying that they decline accepting such office, which is something we need to find out. 45-321. Anybody decline their office? So, okay, well, I got a lot more to talk about, but that's really all I can do. I mean, we just got through oaths and so forth. I got all sorts of things on elections, the CAFR accounts, affidavits of office, notary stuff, blah, 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 blah. But I'm going to save that for part 2. We'll call this good for now. Y'all have a great day. See ya.